I can see it.
Okay, super stuff. So this particular section deals with an extremely important point as far as legal compliance is required within the legal system. You really do have to make sure that there is a legal binding agreement between the two parties. When you hire somebody, you're hiring them specifically to provide a function within your organization. And to that end, you need to define very carefully what the task and the job actually is. Responsibilities, reporting procedures, things of that nature should be definable. And therefore, the other individual needs to agree to it by signing. Both parties signing an agreement of some form or another becomes a contract. And therefore, there is legal consequences for non-compliance. When compensation is due, then it must be defined within the actual document itself so that one party can be held responsible for complicitly providing that particular information or that money available. Let's take a look at this particular section. So it is a direct derivative of common law. Contracts are very, very required. And let's take a look. There are certain things that you have to be aware of. So under common law, the following three things are necessary. One is going to be an offer. Yep, an offer. And then, of course, the second one is the acceptance of the offer. The third one will have to be what is exchanged, and therefore consideration. We often refer to any kind of consideration, whether it is the work that you are to perform or the remuneration you are to receive. So in every situation in a contract, there is a minimum of two entities. And therefore, a contract cannot exist if there's only one. So in other words, if there are one, it's considered to be a gift. In other words, a contract requires the meeting of minds. So two individuals or two entities of one form or another. And there must be some kind of monetary value exchange between the two. So work is actually defined as having a value, and of course, a monetary value that is given to that individual is called consideration, and so is the work. So something is given or promised in exchange between the two parties. That's the key element. The offer is something that is provided, and it's up to you whether or not you accept it. So this is like walking to a cash register with a chocolate bar. Just because you have the chocolate bar doesn't really mean you are going to buy it. It just means that you are in possession of that particular offering, but not necessarily are you going to accept it. You may be ready to negotiate for it. However, acceptance is when something is exchanged of value that is required for that particular product, such as the chocolate bar, you've given money. But until the individual has accepted the money, there really is no acceptance of the actual chocolate bar. So once again, offer, acceptance, and consideration, something of monetary value is exchanged. There are three types of contract which I stipulated before. One is called a written contract. There is an intentional contract, and there's also the verbal contract. Out of the three, the written contract is by far the best of the three because there is an actual, let's say, definitive explanation of each of the terms or clauses or requirements or expectations that have been defined. Within a, let's say, an auditory one where it is just verbal, then there can be misunderstandings. And when it's intention, there also can be misunderstandings. And I'll give you examples of these as we go along. So within a written contract, Advantages of a written contract, we're going to take a look at those. Implied terms within it, and we'll also take a look at the basic written contract covering the following areas, and we'll take a look at those. The biggest issue with a written contract is it is stipulated directly in writing, and therefore there can't be any misunderstanding. One thing about contracts, which sometimes makes it difficult to understand them, is that whatever is written down in a contract must be unimplementable. Boy, this is Friday already. It must be unambiguous. There can be no second possible explanation for a term. So a term has to be very direct and to the point. There cannot be two explanations for it. So it has to be very carefully worded so that there can only be one interpretation. And that makes it difficult to understand contracts sometimes, especially because some of the clauses are very difficult to make sense out of. So they have to be unambiguous, non-ambiguous. So the parties, again, are held to that. Addresses contentious issues. I really need new glasses. So addresses contentious issues early. While both parties have a positive relationship. Remember, this particular document is going to be provided to both parties, and both parties have to agree to it. This does not mean that they have to sign it. In fact, what normally takes place is a contract is provided as an offer, and then, of course, some adjustments may be necessary to it. You never, ever, ever sign a contract that has any kind of markings on it, such as they've excluded or they put an X through something. It has to be retyped. You don't ever sign a contract that somebody has scratched out an area. You make sure they retype it again. It must define absolutely everything within that particular document. If anything ever is missing, such as, let's say the date is missing for termination or what to do under certain circumstances, it can go to a court. But there's a problem with courts. Courts will not change the contract. All they will do is make sure that both parties come together and agree to a satisfied, let's say, or a satisfactory outcome so that they have to put in the entry. But the court will be there as a third party to make sure that it's done properly. Again, this does happen sometimes where a contract may be missing some particular element that needs to be there. You must define things, and therefore reduces uncertainty. Well-drafted contracts are going to provide very clear, direct to the point explanations, in other words, clauses that will define what the duties or the responsibilities are of both parties. It has to be there. So conditions and responsibilities of each party must be definable. And again, oral agreements can be difficult because, let's face it, sometimes you hear only what you want to hear. If you have children, you probably know that. If you have a spouse, you probably know that as well. You say something and they understand something different. So this is one of the paradoxes with the oral type of contract, is that it is kind of based on interpretation. But with written, it is very specific. So it's unambiguous and it has to be very well definable. There are certain terms that you need to be aware of. One of them is implied terms. So what happens when an issue of dispute is raised by one party, but the issue is not addressed in the contract? This is a problem because sometimes you need to have everything definable. For instance, let's say I buy something and they can't deliver it on time. Well, what happens? It has to be defined in the contract. If you don't know what's going to happen, then you could end up being out of pocket. What would happen if I ordered something and I sold it to a customer on the condition that it would be there by a particular date? And then, of course, the supplier is unable to provide the object for me to sell, and therefore the customer sues me. Well, can I sue the supplier? If it's in the contract, yes. If it's not in the contract, no. So you have to make sure that everything is actually in the contract. So these are implied terms. This is the case for most oral contracts. Again, the court will insert the implied term. Usually this is a termination, or it happens to be a definitive pricing or something of that nature, something that both parties can agree to, but it's just not in the contract. So once again, the courts will insert that information, but again, remember one thing, courts really don't like to play around with contracts. And the reason is very simple. They were not present when the contract was created in the first place. So they really don't understand the intention of it. And once again, even though it makes sense that you have an employment contract, they're not too sure why you agreed to accept a contract that didn't include everything. As you probably know, when you go for a job interview, one thing they always ask you is to read the contract. You have some time, take a look at it, read through it, see if there's everything is there for you. If you just simply sign the contract, which many people do, then you could find yourself with serious problems that the contract doesn't contain information. I used to give the example, but the contracts have changed a little bit. And this, excuse me, this used to be for the banking community with your, let's say your convenience cards, your debit card. Debit cards used to be under a very unusual contract, and it made a lot of sense. And this also included any kind of Visa, MasterCard, American Express, Diners Club. They all had the same clause. And the clause was a very specific one if you did any kind of online banking. And that was, there's a very small bit of print on the back of the contracts which stipulated that any errors made by you is your fault. Any errors made by the bank is your fault. Any errors by a third party is your fault, which is quite a nice contract for the bank, but not so much for you. And there's a very good reason for it. When you're doing online work, they don't know who you are. So somebody with your PIN number and your credit card number, they can basically do what they want to do because that is the third party. They don't know who you are. They can't see you. And therefore, it could be fraudulent, but it's your fault because you decided to do online banking, which would not show your presence. You wouldn't actually be able to identify yourself. So this is where a lot of third-party companies came in, such as Wells Fargo, VeriSign, and a variety of other ones, where they actually sign on your behalf. And that guarantees that if anything goes wrong, you still are covered. You have insurance. So contracts need to have everything inserted into them. But the courts will insert something that is obvious and obviously missing. There are terms that parties would likely have agreed to and honored the spirit of the contract. And these are things that can actually be added to the contract by a court, but not by you personally. You would have to break the contract as a collective. The two of you would agree. You'd break the contract and then create a new one with the new information. You cannot adjust a contract. So in other words, you cannot just simply write in the new clause. You have to retype it, and that means the old contract is void and a new contract is brought in. But that requires that both parties agree. As remember, you signed the original contract. That contract is still legally binding, even with the missing parts to it. It's the court's perception of the parties' rights and obligations, or what they should be. or what they ought to be. And that's what they're going to measure any kind of error within a contract. If a contract does not have a closing date, a termination date, then a court can be sequestered in a sense to help you out with that. But they're really trying to get both parties to agree on something. And maybe one party doesn't want to agree. You often notice that some contracts are very specific in how they're terminated. I remember, and I'll give you an example, where I had a Goodyear Good Life membership with a gym, and I tried to cancel it. I phoned them up. I said, it's canceled. No. I went in and talked to them, and I said, I want to cancel it. And they said, no. And I said, well, why can I not cancel it? And he said, read the contract. The contract states that you must, in writing, say that you are canceling your policy. So this is one of those things where there may be something very specific within the contract. And if it's missing entirely and there is no way of actually, let's say, terminating or seeking some kind of remuneration that is not included, it would be extremely difficult to do so without a court. So lack of termination notice is probably one of those areas that should actually be within that contract. The court interprets them, implies the terms of reasonable notice. And again, this would be provincially judged. So you would be looking at whatever is in that particular jurisdiction as a legal consequence that would be added to that contract. But then keep in mind, both parties must agree to it. So what should be within a contract? So written contracts over the following, the basic elements. Once again, a title must be there. The date that it actually begins, it should always be there, because you need to know exactly when it becomes enforceable. And also the salary. So if you entitle if you intend to receive some kind of remuneration, it has to be defined. Because remember, we talked about this yesterday as well and the day before. When it comes to a contract, the only way of getting rid of it is constructive dismissal, because let's say your salary has changed, or the start date has changed, or your title has changed. So maybe you started off in the mailroom as a mailroom clerk, and now all of a sudden you're working at as, let's say, an assistant administrative assistant. Well, that means your title has changed too, so the contract is no longer valid. So constructive dismissal takes place. But if you don't have those elements, it's hard to define what your purpose is within that contract. So any benefits that are paid to you should also be defined, or there should be some kind of variation within it that indicates that they can be changed at a later date if necessary. This often happens where a company buys a particular set of benefits, or they're providing you with some particular benefit, and an adjustment is necessary as time goes on. So there'll be a clause in there that allows them to be flexible in that particular area. Job duties should be definable so that you know what your responsibilities are. And that's a very crucial element, because if it's not there, you could find yourself working at virtually anything. And this means you could be held responsible for virtually any task. So it is necessary to define them so that you know what you're responsible for. And one of the clauses that's often entered into here is because they recognize that sometimes you'll only have a 20-hour week. In other words, there's just not enough work to go on for 40 hours, but you're still being paid for that 40 hours, and you're still expected to be at work. Then what they will do is add an additional clause, and there are many ways of writing that clause, but it usually stipulates that other duties as necessary. So you may be required to perform other duties that are within the same category of what you're doing at that particular job. So they'll define it, and then they may add just that extra clause as well. If it ever becomes necessary that this contract be invalidated in one form or another, or there are conditions why you would be terminated from that employment, they also have to be defined. You can't just simply come up to somebody at the last minute and say, oh, you're fired. You can't do that. You have to have rationalities, and there must be some kind of clause that takes care of that type of situation. So how it's done, what are the conditions of it, things of that nature would actually be in there as well, including maybe a time. So maybe you're working just a project, or it's a term contract where you're only working for a specific period of time. Well, if it doesn't have a date of conclusion or termination, then it just keeps going, and you would definitely be an employee indefinitely. And therefore, the company would have serious problems trying to get rid of you, because they would have to remove your position in order to release you from the company, which also means they would not be able to hire somebody else for that position, because then you would run into wrongful dismissal situations. Disciplinary process also has to be defined, especially if it is significant. It definitely has to be defined so that you know what the ramifications will be. Remember, you're signing an agreement that you will live up to these expectations. And of course, they're going to put in your salary and everything else and the benefits, because they have to live up to those expectations. So if you don't define it, well, you don't have to live up to it. So you want to make sure that everything is taken into consideration in a contract. Probationary period may be necessary, especially when it comes to people who are going to go into a union. Once again, if a company is unionized, chances are the individual after 3 months will be automatically required to join into the union, even though the company may be paying from day number 1. So probationary period may have to be definable. If there's a collective agreement, it will definitely be defined. It could be a month, it could be 3 months, it could be 6 months. It really depends on the type of organization you're going into and what the necessity is within that contract. Absence procedures. And again, we're really trying to just define it, because if you don't know these things, then how are you going to live up to them? How will you be able to carry out your responsibilities? So really what we're doing is we're defining the different things that are necessary for you to live up to and the company. So here we have safety process. Now this may actually incorporate maybe licensing, maybe certificates are required, clothing is required. Who pays for it? Do you actually have to buy it yourself, or does the company supply it? How does it work? So this has to be in the contract. Otherwise, it's just hearsay. And hearsay is not something that you should be listening to. You want to see it in writing. And harassment is also defined within that contract where necessary. So just keep one thing in mind when it comes to a contract. Because there are legal consequences for one party or the other not living up to it, it really needs to be carefully thought out. You just don't throw these things together. It's got to be well thought out for your organization. And that simply means that any job you take on will always have a different contract from, let's say, another company you work for, because the circumstances will be very different, who you're reporting to, what your responsibilities are, and what the ramifications for non-compliance are going to be. And that goes for both parties. So it's really got to be well thought out. And most companies do not create their own. They have a lawyer do it for them. and it's very carefully thought out what is required from both parties. Enforceability and also interpretation of a written contract. And again, written contracts are much better than any of the other two varieties. A party who is unhappy with the terms of the contract can challenge the contract's enforceability. And again, you don't have to sign one of these. It's offered to you. It's up to you to accept it. If you accept it and you sign it, you are now legally responsible for fulfilling the obligations of that contract. And this is also why, by law, any company that asks you to sign a contract must provide you with time to read it. So this is why human resource departments always tell you, take a good look at it, read through the contract, and then sign it. Or take it home and read it if you want to. Take it to a lawyer if you have to. For some high positions, you may want to take it to a lawyer. But at least go through it. Don't just simply sign something, because if they've made a mistake or they've added something that you're not aware of and they haven't talked about, you're still held responsible for it because you signed it. And you can't go to a court and tell them, well, I didn't see that. That's not a good excuse. Ignorance of the legal system just is not an excuse. You must read your contracts. So never, ever, ever sign a contract without taking the time to read through it. And you can take them home and you can take them to somebody else and have them read it with you. But there's one other little caveat here, and it's very important in Ontario. If someone asks you to sign a contract, they also must be capable of explaining it. And this means if there are any clauses or any statements within that particular document that you don't quite understand, they must find a way of resolving and explaining it to you. So if they can't explain it, then they have to get somebody who can. So when you ask somebody to explain a clause within a contract, it's up to them to be able to do that for you because they want you to sign it. So just keep those things in mind. There's an example here. Terminated employees can challenge the notice term if it does not meet the minimum standards. So once again, this is a situation where maybe standards change. Today they're one thing, tomorrow they're another. So again, it depends on which political party is in. They may change the law. So if your contract is not up to speed and nobody has constructively dismissed it and created a new one for you, then you can challenge these things. So once again, if something is in there and you don't believe that it's enforceable under the circumstances, then you do have the right to challenge it. Employer needs to be aware of the issues set out below. So let's take a look at some of those pitfalls. Lack of consideration. Maybe you didn't pay the individual. Well, once again, there's a legal requirement that you sign that contract with the employee, and therefore you are responsible for consideration. Or maybe the employee didn't provide enough actual work, and therefore consideration was lacking as well. Inadequacy of the bargaining power, inequality, in other words. So here's we come into a situation where, let's say, one party is weaker than the other party. And also obsolescence. These are just some of the factors that need to be taken into consideration. Failure to meet the minimum standards that are required, statutory standards. Use of ambiguous language. And as I said, contracts cannot have ambiguous language. One of the problems with contracts is they must have only one possible answer for every clause. So a clause cannot have multiple interpretations. When it's read in English, it can only have one meaning. And this is where the ambiguity comes into it. If there's any ambiguity in it whatsoever, then that contract could be contested. Uh, you often notice this, one of the prime examples is when you're looking at the government and the government is passing a new bill. It's always sent to the uh, Senate so that it can be evaluated to determine whether or not the wording can actually be misunderstood or have a loophole in it. So once again, that would be an ambiguous language clause. So lack of consideration, promised exchange of payment for work performed. Again, if the compensation is not provided, there are legal consequences, and maybe within the contract it stipulates that you can sue them, or maybe within the contract it stipulates that there is something else, some other kind of action that can take place. So this particular situation can exist when an employee begins work before the contract is even finalized. So there's no consideration during that particular period of time, but it's not really necessarily in the contract, and the start date has not actually been set up properly. Or contract could be unenforceable given the nature of the work. Maybe it's illegal or has changed since the date that it started. I can give you a really good example of that one, but it's a verbal contract. So listen carefully. I knew a fella who was a senior vice president, and he actually was looking for a new job. He met with the owner of a company in Hamilton, and they had dinner. And the fellow really liked him. He's a controller, so he's a financial expert. And he was hired by the owner of the company and told to be there next morning. And he'd start and he'd introduce him to all the other executives in the company. So the following morning, he showed up bright and early. And when he went in, people wanted to know, who are you? Because you didn't go through human resources. Who are you? And of course, they couldn't figure out who he was. And he said, well, wait a minute now, the owner of the company had hired me yesterday. So yesterday evening, I was hired for this particular position. So we have a contract, we have a verbal contract. And they pointed out something that he didn't know either. And that was that the owner had passed away during the evening. So, and this is a true story, by the way. So unfortunately, he didn't get the job simply because he only had a verbal contract, and the only people aware of it, one was already dead and himself. So unfortunately, he didn't get the job. But that's a verbal contract. And once again, it may not be documented, so nobody else would be aware of it. If it had even been written on a napkin that he had been hired by the other person, he would have had the job immediately. But because it was verbal between himself and someone who no longer existed, then it was impossible to validate that it actually existed. Consideration is out of date, inadequate consideration, and there could be reasons for this. Let's say you started at $10 an hour, but the minimum wage went up to $14 an hour and your contract said $10. Well, of course, this means that the consideration is out of date as well. Or maybe that position has changed within the company, or union has changed the value in their collective agreement, and it cannot be reflected within your contract, which is out of date. And to avoid this, ensure that the contract is complete before the beginning. So the job is actually going to begin on a specific date. Make sure everything is up to date in that contract. And again, because you're human resources, it's up to you to monitor these things to make sure that they are correct. Inequality in the bargaining power. So there are situations where sometimes people are taken advantage of because they don't know, maybe they just don't know how to read a contract. Maybe they don't believe that they should walk away from a contract, but there may be unconscionable clauses or statements within a contract that they should probably be aware of, and they're not. And sometimes companies do take advantage of people. This used to be a serious problem for secondhand cars. When you were buying an old car from an unreputable car dealership, you may have actually been forced into it saying, well, somebody else wants to buy it, and if you don't buy it right now, and then you couldn't even get it off the lot because it wouldn't start. So unconscionable agreements are ones that are unreasonable. They're one-sided contracts, and this is a problem for a contract because it must be two-sided. It results from an inequality of the bargaining power of one of the participants, and it's almost always the person who needs to sign it, not the person who created the contract. So when it actually goes before a court of law will normally take the position of the individual who signed it rather than the person who created it, because sometimes the person who signed it just didn't have enough knowledge to be able to enter into such an agreement. And this is also the problem I mentioned only a little while ago, where courts don't like to interfere with a contract because they weren't there and they don't know why you would have signed it in the first place. So employees can't say no or don't understand. Once you sign that contract, that's it. You've signed that you agree to whatever is in it. And this is why it's so paramount that you read the contract carefully and that you understand it. And this is also why I said in Ontario, it's a requirement. The company who is providing with the contract must be able to explain it to you if there's something you don't understand. But they'll never explain anything if you don't ask. And you won't be able to ask if you don't read it. So you need to read the contracts. To minimize the risk of creating any kind of inequality of the bargaining power, the employer can do the following. Ensure terms are reasonable for both parties, but sometimes reasonable, depending on the complexity of the job, may actually be difficult to understand. Sometimes it's not just straightforward, but it has only one outcome meaning. So once again, we try to make it even simpler still. Providing recent copy and also give time for the employee to read it before signing. So this is just kind of like saying, if you don't read it, it's your problem, your fault. Including a provision that candidates have opportunities to obtain independent legal advice. As I mentioned just a few minutes ago, you should always read that contract. And if you don't understand something, you should ask them to give you some time to go and talk to somebody to look at it. One area I really stress is when you are signing a contract as a contracted employee. In other words, you're not really their employee, they're just contracting your service. That's a slightly different element. And the reason I'm saying that is because sometimes employers do not understand the legal system well enough to recognize that what they're asking you to do legally is make you an employee, but they're thinking you're going to be a separate individual. In other words, self-employed individual as a contractor. If that's the case, then the legal system looks at you as your own business, and therefore you have your own rights. You're not supervised. You don't have a manager. You are the manager. So these are things that you really do need sometimes to take a close look at. I did give you a horror story of a friend of mine who got hit with a $35,000 tax simply because for a number of years working for a government agency as a contractor, not an employee, as far as the government was concerned, he was working under their authority, but in reality, because he was a contractor, he really is a self-employed individual and therefore cannot be managed. And Revenue Canada is the one who came in and hit him and over 1,000 other employees working for the health ministry, which is what the department was. And of course, the health ministry got hit with a number of fines, but it doesn't help a great deal, especially when you're not prepared for that. So you want to check your contracts really carefully, especially if they're a little difficult to understand and they can't explain it to you. Draw the employee's attention to key terms. This is something that most companies will do, especially larger companies. Human resource departments in larger companies are well trained. They usually are very well educated. They've had many courses on doing different elements and dealing with legal issues. So they have lots of experience and they train their people to have that experience. So in this situation, what you normally would end up with is somebody who would actually point out certain pages, certain clauses, so that you really understand what you're about to sign, because they don't want you to be upset at some point because you didn't understand something. Obsolescence is another thing that can actually affect a contract. It literally can become out of date. Let's face it, if you've ever worked anywhere, you know one thing for sure. Nothing is stagnant. It's constantly changing. And therefore, a job that you may have had 2 years ago, you're doing different things now, or you're doing more than you did before, which is probably not even in your contract. So you have to remember something. Contracts can actually be out of date, so much so that you can't even hold the employee responsible and you can't hold the employer responsible because neither party is living up to what the original agreement was. So obsolescence can actually be in there. And one of the big issues that often happens, and this is where we get the constructive dismissal again, is promotions, a junior position to a management over a number of years. Well, I can't hold you to, let's say, being a clerk in the mailroom department if you're now a supervisor of another department, because your duties are totally different. Your salary is different. Your, let's say, your requirements, your responsibilities, everything has changed. So that contract is totally obsolescent. And of course, the result here is we need to do a constructive dismissal. In other words, the old contract is voided by agreement. And remember, this is important. It must be an agreement so that you intend to rewrite the contract or provide a new contract. So nature of work has changed, but no new contract has been signed. This is when you have obsolescence. And updating the employee agreement after a promotion or a change in the duties to avoid future issues. Because remember, you cannot hold an employee responsible for anything that is not defined within that original agreement. One of the other things that has to be in a contract is an understanding and an expectation that the contract includes all standard or statutory, let's say, standards that need to be applied to it. So minimum wage has been taken into consideration, so it's not obsolescent, and anything else that needs to be adjusted has been adjusted within the contract. These are outlined in the Employment Standards Act of 2000. We covered this in the last section, so section number 11 or chapter number 11. Contracts not enforceable if below the minimum wage. Remember, it cannot be a one-sided agreement and it can't be illegal. So all the clauses within it have to be legally binding, and you can't have something that is irregular, that doesn't even live up to the standards. The use of ambiguous language. So employers should use clear and unambiguous terms. But one of the things that often happens in a contract is, in order to make sure that there can be no misunderstanding, it will be written very, very straightforward. but sometimes that's very difficult to understand. If you've ever read a contract, usually it's quite easy to read, but there are those terms that don't quite make sense, but they only have one outcome, one meaning, and they're not ambiguous. So they're very specific and to the point. If ambiguous language is used and there is more than one possible meaning, and this is the problem, then literally the person who signs it is going to be the person that is favored. So the court will interpret in favor of the non-drafting party. So this is the employee, because the employee may not really have understood the legal jargon used. And in many cases, contracts do have some legal element to it, which holds both parties. But if it has multiple meanings, that one sentence or that one clause, then it becomes very difficult to hold somebody responsible to it. And this is known as contra preferentum. Preferentum? Okay. Contra preferentum. Proferentum. It's been a while since I've done a legal course. Fantastic. And in this situation here, so using clear language and also being fair when negotiating the terms, these are all things that you definitely want to be associated with when you're creating a contract. Giving the employee time to read it is really important. It has to be there because a lot of times the contracts can be really complicated, and sometimes the contracts can be very simplistic. It's really a question of what kind of duties or responsibilities will you have as well, and what are the things that you have to be participating within. So meeting or exceeding the minimum statutory standards should also be something that is within a contract when you're drafting it. Bringing critical terms to the employee's attention. So having the initials, those terms on the contract. Once again, many companies will actually provide a little area for you to initial. And it's only because it's a very stringent or poignant point that they want you to understand for sure. And it could be the hours of work. It could be when paychecks are paid. In other words, when remuneration is paid. Maybe you're paid the second week. So every other week you're paid, or twice a month. It could be either way. So twice a month, well, of course, you're going to run into 3 weeks, one period, and 2 weeks for the next one. They want you to understand that. And maybe you have the use of a car, so they want you to initial that you have to take care of that car, or you're responsible for something about the car, or credit cards or something of that nature. If you're in a management position, chances are there's going to be a number of these where you sign for credit cards, debit cards, and a variety of other things that might be necessary, like let's say monies that are paid to you to be dispersed to people. Providing additional consideration, if the employer wants to include that, they're actually going to have that in their contract as well. And customizing the contract, beginning with a standard form. There are a lot of standard forms out there of contracts. You just simply fill in the variations that you might want. But most companies are smart enough to get a lawyer to fill it out. In other words, they will provide one specifically for that company. You can buy contracts at Grand & Toy and a variety of other places, Staples, for instance, but you're much better off to go to a lawyer, pay them a couple of $100 and get them to actually create it specifically for your company. Common contract terms that are used, and you do need to be aware of these. Standard contract should only be a starting point. So once again, we start off with the basic and then we start to add to it. So employment contract should be customized to reflect your particular situation between the employee that you're hiring and the company. It should be very customized to that. And written contracts reduce the risk of misunderstanding. Again, there are three different kinds of contract. And of course, it also reduces the possibility of disputes. So litigation is going to be an expensive proposition for both parties, and this is best not taken into consideration. What we really want to do is make sure the contract is really well defined. So including any terms, excluding any terms, including any of the terms that are prohibited by law as well, need also be taken into consideration. Some of the terms that are used, the common ones, a description of the job, so a job description. The remuneration is defined. So this is not just simply they put these words in there, they actually have to define it. So this makes it easier for somebody creating an actual contract. The term, how long is this contract going to be, let's say, used? In other words, when do you start, when do you terminate that employee? Or is it forever? In other words, this is a full-time contract. You can still terminate it, but you have to define this is a full-time position, this is a part-time position, this is a term position. In other words, it's only good for a certain period of time. Termination, and how will you actually bring that contract to an end? How will they recognize it? Are there any considerations that are paid out or given out during that period of time? Probationary period, define it. Define what the requirements are for it, and also the ramifications for non-conclusion of it. Relocation, if necessary, it has to be defined. You can't just simply assume that the employee will understand that. It has to be in writing. Any benefits that are paid, this could be a variety of different areas. Benefits can be inclusive of so many different aspects, but it has to be definable. And also restrictive covenants. Should you be knowledgeable about certain things on that particular company, such as your wages, the amount of money you're receiving, or for instance, a particular process or any particular information, financial information about the company, or methods of doing business or customer lists. This means you cannot, and it will be in there that you cannot share that information with anyone. So restrictive covenants are really definable when they are necessary. Ownership of intellectual property. What this actually means is you have to be very careful. I can actually give you an example of this one. If you invented something or you came up with an idea, and the company decided, well, we're not going to do anything about that, you can't do it yourself. So just to give you an example of what I mean by that, this is actually both H and L, H and I should say. What is unique here is there was a story not that long ago, maybe 12 years ago, of two young fellows who worked for a wire company. And this company made wire, and of course the company was asking its employees to give them suggestions. What should we do? Is there any other product that we could create? The only thing they were manufacturing was wire. So two fellows actually thought about it, and they played around a little bit with some small cuts of wire, and they started to build shelves out of them. Now, nowadays, if you go to any like Home Depot or Rona or Canada Tire, or most different places, you'll often see these wire shelves, which are usually coated with a thin white plastic, and you can put them in a closet or something of that nature. You just cut them to size. They came up with this idea. They put it in as a suggestion. And of course, the company said, well, we're not really in the shelving industry, we're in the wire industry. So this idea we can't use, but thanks for submitting it. So the two of them thought it was such a great idea, they quit. and they went and started their own company, and they got some funding and they started making these shelves. Well, the company that had literally, let's say, owned the wire, was making the wire, and had hired them originally, ended up suing them because they violated the contract. Within the contract of their original employment with that wire company, it pointed out that anything that was introduced to that company was owned by that company. So the fact that they were employees at the time, therefore earning an income from that company, and they had supplied a suggestion, that suggestion is now owned by that company. Okay, and unfortunately, the courts agreed that because they had been employees, they had been earning a wage at that time, and they came up with a great idea, they would have been smarter to keep it to themselves. Okay, then they would have been able to start their own company and no one would have been the wiser. But unfortunately, they shared the idea while being employees, and that was a direct violation of their contract, which simply stated that anything created while they're employees earning a living in the company, this doesn't mean at home, just means in the company, they gave the suggestion and therefore it's owned by the company. So this is another reason why you want to read your contract, because you may find something unusual like that. I also gave you an example of a friend of mine who works for Glaxo. She's worked for many different companies, but one of the things she absolutely demands within a contract when she actually works for a company, a pharmaceutical company, is that anything that she invents, she keeps, but they get to use the product. In other words, she has the patent. They don't have the patent. So again, this would be who owns that intellectual property. And you definitely want to make sure you read carefully. Even here at Trios, we have that agreement that if an instructor introduces some particular training method, that method belongs to the company. It doesn't belong to the instructor. So again, that's part of a relationship you have within that contract. The choice of law, also the corporate policies, and also the entire agreement clause, inducements, if there are any inducements in there, independent legal advice, and also severability clause. So what happens when there is a breakdown and let's say the individual is released from the company, and also the golden parachute. We'll talk about these ones as we go along. So the first part is the job description. You really do have to make sure that the employee understands it. And once again, it can't include something that they are not going to be responsible for. So it clarifies the expectations that both parties should have within that particular agreement. The employee is entitled to refuse to perform any duties that are not in that contract. So if the contract is above and beyond, in other words, the duties are above and beyond the contract, then the employee does not have to do those functions, whatever they happen to be. This is why I said near the beginning of today, within a contract, sometimes the employer will put in an additional clause within the job description that defines other jobs as may be needed or necessary. There are many ways of writing that. And it just simply, it's an open clause so that if the individual were, let's say, working at a desk and they had a few hours in a day, then the employer could ask them to do other things that are associated with what they're doing. So inserting a clause that allows the employer to change the duties of the job, which is what I just mentioned. Any and all other duties as may really be required from time to time is another way of putting that clause. So again, it really depends on how it's structured. And an individual may not have a full 8-hour day that they have to consistently work at. they may have 2 or 3 hours of extra time during that day. So the employer has the right to fill it because they're paying you for it. So that clause must be there. If that clause is not there, you don't have to do it. Okay. Again, this is why you need to read your contract, know exactly what's in it. The next issue is if I know what the job is, then I need to know how well am I getting paid for this and what kind of payment. So in this case here, it has to meet at least the minimum $14 an hour, or depending on what you're doing, if you're a bartender or something like that. And higher than minimum wage, well, of course, if it's going to be, I want to stipulate that because the minimum would be the $14 an hour. More than time and a half for overtime. Some companies, as I mentioned yesterday, do in fact pay more than time and a half. Some of them pay a shift premium above and beyond that. So you need to define that so that a person recognizes, yes, a shift premium will be paid. And no obligation to provide for future pay increases. Well, that's not going to be in your contract, but there is the potential. And if it is in there, it means that on a yearly basis, they would give you a little bit more every year, but that would be in your contract. So again, the stipulation may be there. Executive contracts may contain details of bonuses, structures, and stock options. It will definitely be in for executives. Senior management, high senior management, will always have what's called a golden parachute, and they'll have a lot of different things in order to get rid of them or in order to keep them. And everything will be very carefully defined. The term is also important for us to understand because if it's missing, then you don't really know what that contract is going to be for. So as it points out here, a fixed term contract must state the terms of the task. So in this case here, a fixed term contract allows the employer to reevaluate working relationships on a regular basis, but it needs to be in there. And there are two kinds of contract. So employer cannot use a series of rolling contracts to avoid statutory termination requirements. Again, the information that you're signing is going to hold both of you legally responsible to one another. Some of the administrative challenges that come along with fixed contracts, especially when it comes to certain conditions like the term of the actual contract, renewal dates that are missing, the contract becomes for an indefinite term. So if this particular contract is not a yearly contract or a bi-yearly contract, then of course it just goes on forever. But at some point it's going to become obsolescent, and therefore it needs to be monitored and watched by human resources. Issues of termination. Employer seeks to terminate a fixed contract. Damages are based on the remaining term. So let's say it's a year contract and they decide to cancel it halfway through. They have to pay you for the difference if the contract stipulates it. If the contract said it was for 12 months, then some kind of condition has to be in there of what happens if it's not 12 months. This often happens when a contract is needed for, let's say you're doing a particular project and the project is a full year, but it only takes you 8 months to complete it. Well, how do you not get paid for the other months that you agreed to? You agreed to do 12 months. So there has to be a condition in there that will actually tell you what happens during the termination process. Fixed term, 10-month contract. Well, in that case here, it terminated 2 months in, and the employer may be liable for the remaining 8 months. But if they don't even put it in the contract, how would you ever make sense out of it and know what should be paid and what should not be paid? So normal contracts, the employer is liable for a common law notice of 2 months. Again, they need to let you know that this contract is going to be null and void at a certain point. But once again, there may be a necessity to make sure that there is a clause in there that stipulates that when it is terminated early, that you're still kind of protected. So once again, we want to make sure that we're covering ourselves when we're signing a particular contract. And when we're creating one, we want to make sure that everything is defined in it. So with that termination notice, tends to be most contentious. Again, you want to make sure that it is very clearly defined what happens. Common law presumption of reasonable notice applies. And again, what is reasonable notice? Well, we're looking at our 2 months. Termination clause needs to be clearly expressed within the contract. Remember, everything needs to be definable and clearly brought to the employee's attention. If the employee doesn't know it, there's definitely going to be contention somewhere along the line. And chances are it will end up going to a court. So in order to avoid that possibility, because it's expensive to do these things, go to a court, then you want to make sure that you've covered as many bases as possible. For a lawyer will know exactly what needs to be in that contract because they are totally aware of their field within law. And just to give you a quick example, I had a contract made up a long time ago, quite a few years ago. I decided to go into a partnership with two other guys, and we started a big business. When I thought about it, we had spent an entire weekend, something like this weekend, just kind of banding ideas back and forth, and we created a partnership agreement. But we're going to incorporate, so I needed to make sure that it was a contract between us. And I got a little bit skittish because I was putting up quite a bit of money, and so were they. So I went to a lawyer, and I thought we came up with, I think, if I remember correctly, it was about 3 or 4 pages of things that we wanted in there. And when I went to the lawyer, I had a long talk with the guy. I explained what we wanted to do, and he created a contract for me, which took him a week. And at the end of the week, I went and picked it up. It was 150 pages in length. This will give you an idea of some of the things that can legally go wrong for a partnership. So you can imagine that an employee and an employer, they have a special relationship as well. And you want to make sure that everything is defined. Now, this doesn't mean you're going to have a 100-page contract, but it does mean maybe you'll have a 3-page contract or a 5-page contract, or maybe a 2-page for a very simple job, like let's say working in a factory or something. So it's not going to be really complex, but it definitely must define these things. Otherwise, you can't hold them responsible for it. And unfortunately, the employee can sue you if they find that maybe you're taking advantage of them. So both parties need to sign off on it. Whatever that termination is going to be, that contract must be initialed and signed, that they understand that, because this is an important area. How will you terminate that contract? May also set out the methods by which the termination pay is to be paid. For some situations, this could be paid over a period of time. For other situations, it could be a lump sum or a salary continuance over a period of time. If you're a senior manager, chances are you won't be paid your salary until the end of the year. So if you're halfway through the year, they're going to pay you to the end because they do not want to get sued by you. And when you're in higher management positions, your contract is very specific to your function. And you'll discover that these people really do know their rights. Addressing issues of the employee's obligation to provide advance notice of resignation. So sometimes your position is so necessary to the company that it may be necessary for the company to ensure they're not going to be left cold. You could just walk out on them, and that could leave them in a really terrible position. So in the contract, it may stipulate that no, you can't do that. You have to give them at least a month, or you have to give them 2 weeks at least. But it's going to be in the contract above and beyond everything else. And it's your agreement with that company. Usually 2 weeks, unless more skilled, which means it could be much longer. And again, it depends on where it is too, because if you happen to be in the Northern Ontario area and you're the only person who understands how to, let's say, fix a gas line or something like that within 1,000 miles, then you're going to be there for 6 months, whether you want to jump ship or not, because you signed the contract. Again, it's really a question of what you're doing, what the industry is, what kind of contract it is, and what kind of job you're doing. The other area which we talked about was probationary. And once again, there are many different, let's say, terms for probationary, allowing an employee to evaluate, the employer to evaluate the employee's suitability to fit in with the rest of the company. And again, that could be a short period of time or it could be a very long period of time. It just depends on the company. Employees of less than 3 months are not entitled to any form of termination notice. You can just simply be walked to the door and say goodbye. Or termination pay as outlined within the Employment Standards Act. Again, it depends on the agreement of the two parties, which particular direction they go, and how long that period is. So yes, 3 months, but sometimes it can be 6 months, or it could be longer. It just depends on what that particular position is. And the employer, by the way, cannot actually decide, I'm just simply not going to do it. I'm not going to pay. So you cannot avoid, employer can avoid termination pay. What am I saying? And also, if a 6-month probationary period is included, it must provide 1 week's notice of termination to meet the standards, so in the Employment Standards Act. One of the other things that is oftentimes in a contract, especially when a person is expected to relocate. So if a transfer to another city is a possibility, then it must be defined within the contract. This does happen from time to time, that an individual signs a contract in one jurisdiction, but may have to actually go to another to work. And therefore, that needs to be within the contract. Often noticed with RCMP or pipe workers, these people actually do sign a contract in one location, but then they're sent somewhere else entirely to work. If not, the request to move to the other city could result in constructive dismissal. In this situation, what you really have is the individual has refused to go, and therefore you have to cut off the contract at that particular point. There's also the need to define what kind of benefits the individual is going to be receiving. So what are the entitlements that are going to be recognized by that particular employee? So medical and dental, if they're there, they must be defined. One of the things that often happens, however, with benefits is they may be stipulated within the contract, but there may have to be an amendment to that contract, because many human resource departments are constantly changing, let's say, the insurance companies that are providing these benefits. Sometimes the insurance companies increase the weekly or monthly tally for each one of the employees, and sometimes you look for a better package with somebody else. So there may be slight variations that take place, but employees will always be informed of those changes and will also be given an agreement that they are accepting those changes. Vacation pay is also a benefit, and it has to be defined. Remember, 4%, and yet at the same time, it could be higher, 6%, depending on whether or not you've been there for 5 years and above. The company may also decide to pay you more. But if it's not defined, you can't really say, wait a minute, now you told me I was getting that. Use of a car, company car, needs to be in a contract, because who pays for it if it gets damaged? And what happens when you're using it? What happens when you're terminated? You get to keep the car, which would be nice. Holidays, what is the requirement for holidays? In other words, can I just take them anytime? Or are there exclusions? Or is there a process? Or how many weeks am I entitled to? All of these things need to be defined as well. And training and development, do you receive it? If you receive it, who pays for it? When do you get paid back if you paid for it and they're going to pay you when you successfully complete a course? What kind of development will they pay for? What kind of training will they pay for? If it's not defined, then an employee theoretically could just go and get trained anywhere, doing anything, whether it fits the job or not. So once again, it must be definable. This is an area that doesn't always appear in a contract, unless, of course, a company is worried about, let's say, its copyrights or its patents or its processes. It may actually have an advantage over everybody else in the industry. So there may actually be different things that it wants to restrict. A clause that protects the employer's business interests. So it may actually, and here's another one that often does appear. And let's just say there's 2 or 3 companies that actually do exactly the same thing, and they're within a few miles of one another. There may be a restrictive covenant that stipulates that if you leave the company, you can't work for them. You can't work for the other 2 companies because they're too close, and therefore they're competing directly with this particular company. This could also be the case in many situations where there are a lot of companies doing the same thing, and there's several of them that are clustered within, let's say, the same industrial park or something of that nature, where the businesses are very close. Again, there may be a caveat in there that stipulates you cannot literally work for one of the competitors within the local area or within so many miles. Again, this is to protect that company. However, there is a judicial clause that also needs to be there, and that is, if there is no other work that you are qualified for, then you can go and work for those companies, irrespective of any kind of restrictive covenant. So non-disclosure clauses, cannot share confidential information. Every insurance broker in Canada has to sign this agreement. And the reason is because brokers in insurance companies, they oftentimes jump from one agency to another, but they often take their customers. And remember, they were paid a salary while they were acquiring those customers. So theoretically, the customer belongs to the agency, not to the broker. So they have to sign these agreements that they cannot take those customers as well when they leave. Non-solicitation clause is another important one. Again, this is stealing customers, but it can also be stealing employees. For, let's say that you go to another company and you decide you would like to acquire some of the employees from the other company. Well, that's not permitted by law. And the other thing here is stealing customers. Remember, you were paid to be an employee, and therefore during that period of time, you were acquiring customers which theoretically belong to and are property of the other company that you left. Non-competition clause, preventing a departing employee from competing with the employer for a specific time after employment ends. This is a very common clause. One of the reasons for this is you may actually discover there's a better way of doing it, and you start your own company. Well, within a certain period of time, it means that they would not have that knowledge and you would have it, and yet you know what they do. So that means you could really do a lot of damage to that company. So there is a non-competition clause most times. If a person sells a company, there's always going to be some condition in there to prevent them from competing with the original company. And the same is true for an employee. Non-disclosure clauses are usually enforceable, very much so in a court. Non-solicitation and non-competition clauses are more difficult to enforce. Let's just face it, as it points out, and I've already said this, you may have no other choice. You have to go and work at the competition, whether you like it or not, or you may have to start up another company. You just don't have a choice. Or you have to go and work for the competition and they're right next door. So you're going to use the same knowledge you had at the previous company, which means you're going to be competing directly. And solicitation, well, you may have no choice. You may have to knock on doors again, and maybe the doors you're knocking on are the customers you had before. But now you're telling them you're working for another company. So the impact on the employee's rights to earn a living is paramount here. So literally the legal system looks at it this way. If there's no other alternative, then you have to do what you have to do to survive. And therefore, in this case, it might be really difficult to kind of hold that up in a court of law. So this particular covenant is viewed as a restraint on trade, and also they're presumed invalid unless the employee shows, and let's just take a look at what they show, necessary to protect the employer's legitimate business interests. If the business has come up with something very, very specific, like let's say a specific technology, and you're aware of that, you cannot divulge that in the new company you end up working for. So this could actually be held up in a court. When this happens, by the way, the company who hired you can also be sued. So this is something that many companies are very cognizant of, that if an individual left your company, they took, let's say, technical knowledge with them of your operations, and they gave it to the new company by doing it or implementing those strategies at the new company, both you and the company that you're now working for can both be sued. And this can actually be very significant. And I'll give you an example of it. Even though it is slightly different example, it's the same idea. In Mississauga, there is a company doing very specific biochemical work. And one of the senior, I guess you could call them engineers or scientists, actually called a friend of his in British Columbia and was kind of didn't understand something and asked the guy to explain it. Well, the other guy asked him to explain exactly what he was applying it to. And as he described it, he literally couldn't describe it very well. So he had to send him all of his research, and he sent it as a fax. Well, the other company got a hold of it, of course, ended up trying to apply a patent against it because they realized what the issue was. But the company in Mississauga ended up suing for several $100 million, both the scientist that is employed by themselves, and also the scientist on the British Columbia side, and also the company in British Columbia, because that's called industrial espionage. You can't steal somebody else's work. So this is kind of an important area, because once again, it may be a legitimate reason why the company has, probably spent a lot of money researching or creating a method of doing something that's unique. And you don't want your competition to simply walk away with it by hiring somebody that used to work for you. Non-competition covers a reasonable length of time. Everything changes, and maybe this is a 12-month thing or 2 years, or it might be a 5-year clause, which is normal within the industry. So 5 years, and at the end of 5 years, you can then begin to work for somebody else in your local area. The court's more likely to find restrictive covenants is valid if the employee is given a genuine opportunity to negotiate the terms and also to seek legal advice when contract is being signed. Remember, I gave you the example of a friend of mine, Xiaopin. In her situation, she always guarantees that one clause be added to the contract. And that stipulation is anything she creates is her property, and the company gets to use it. So they're quite happy with that fact. In fact, a lot of companies like that idea. So she owns a whole bunch of patents, and different pharmaceutical companies she's worked for in the past, each one of them had the rights to use that particular product, whatever it is. But you would have to make sure it's there in that contract. The courts are aware of the potential power imbalance, let's face it, between the employee and the employer. The employer is definitely going to have more power in most situations. Again, it depends on how hungry they are for a particular employee, because that could switch over to the opposite direction. Ambiguous covenants are by definition unreasonable and therefore unenforceable. So you can't tell somebody you can never work for somebody else, or you can never work for the competition, that particular company, ever. You can't do that. So that would be ambiguous. It would also be totally unreasonable. You just can't do things like that. But you could put a clause that stipulates after a year you can work for them, but not up to that period. Remember, industry changes so quickly with its techniques and its, let's say, its methodologies and the way it actually interacts within the environment, that things change very quickly. And therefore, if you don't keep up or you don't kind of move forward, then you're going to be left behind. Most companies, within a year, they've changed their processes. The ownership of intellectual property, this is another important area for us. This is one that you really, if you're in an environment where you have great ideas and you like sharing those ideas, you want to make sure that you are protected, because many companies will put a clause in there that means that they own everything. If you come up with an idea while you're on the job, so to speak, it's theirs. So it's sometimes better not to open your mouth while you're at work, but do it at home. In other words, if you invent something, do it at home. Don't do it at work. So this clause covers everything from inventions to patents, copyrights, created by the employee. And again, it's during the course of employment. So it's during the hours that you're working. So if you do this on your drive home at the end of the night, it's your idea. If you do it while you're on their property, going to your car in the parking lot, it's their property. Okay, so just keep in mind, it has a lot to do with the boundaries. So it's vital to have a clause that outlines that all intellectual properties of an invention belong to the employer. Remember, they're paying you to be there and work. And if you're coming up with ideas of better ways of doing that work, then it belongs to them, because they're paying you for the privilege of you actually being there and doing something, thinking of something, inspiring, whatever it happens to be. And to be quite honest with you, that clause does appear a lot in contracts. Choice of law, a clause that outlines which provincial law will apply to your particular contract. A lot of people work in other provinces or even other states. So you might be in Ontario working at a company here, but maybe you also are working in the United States or you're working in Quebec, or you're working in Manitoba or British Columbia or someplace like that. So it's really important that we understand where the jurisdiction is, which legal jurisdiction, which province, in other words, are you going to be held accountable? An Ontario employee and Ontario employer and employee contract is under Ontario law. So it may not be totally enforceable within Quebec, or maybe in Prince Edward Island, it's not totally enforceable. There may be elements that are, and there may be elements that are not. Again, it depends on the jurisdiction. It is possible to have a choice of another province or jurisdictional law, and again, it can be presented within the contract. So this is just a category within the contract that may actually stipulate that you are working in another location. I used to have a friend who worked in France. He worked in Paris, and it was for an Ontario-based company. So any legal disputes he also had within the contract that he could actually go to a French court as well as an Ontario court. And there must also be reasonable connection between the employment contract and the chosen jurisdiction to be enforceable. Once again, if you're working in Quebec, then obviously Quebec is going to be your choice rather than Ontario, even though you are hired in Ontario. If you're working in Manitoba, it's the same thing. You're probably going to be spending far more time there, and therefore it would be easier for you to use the jurisdiction there than Ontario. And corporate policies. Excuse me. It's also important to have elements within your contract that dictate and also identify any contractual binding the employee to general policies of the company. Excuse me. So it's important to have these clauses in there so that you actually know how the policies will impact the actual employee themselves. The employee, by signing the contract, is agreeing to particular standards of behavior. Well, if they don't know those policies, you can't hold them responsible to them. It's a moot point because, once again, you definitely need to define everything within a contract. And again, the employee should be given a copy of any particular manual. There are many different ways of doing this. It could be an employee manual or it could be a policy manual. In order for them to go through it, what normally should take place is that they have to sign for it. In other words, they sign that they have read it or that they have gone through it in some particular way or through the policies you wanted them to explore. And it can be done electrically. A lot of companies have switched over to this rather than printing manuals. CIBC used to have one which was over 100 pages, and it was difficult for employees to take the time to read through it. So at home, they could do it if it was electronic, and that's how they've switched it over in many cases. Giving time for the employee to review before signing the agreement. You have to be realistic. Once again, it cannot be unconscionable or unreasonable. You have to make sure that they do have enough time to make sense of it. And you also have to be able, within the human resource department, to be able to explain these elements as well. So if there are policies that don't make a lot of sense, you need to be able to explain why they were enacted and how they affect the employee. So here we have the exemptions as well. If an employee actually wants exemptions on specific items, this should be specified in a written contract. Again, remember the contract is specific to the employee. So if an adjustment is necessary within that contract, it's going to be typed into that contract so that there are exceptions. But once again, you don't get anything unless you ask for it, and you're not going to notice it missing unless you read it. So you got to make sure that you are reading the contract. There's another term here, which is the entire agreement clause. So this particular statement actually clearly states that the signed contract constitutes an entire agreement. When you sign that contract, it's for everything within that particular contract. Previous negotiations, conversations, and promises, they're not part of this. It's only what has been documented. And remember, there are three different types of contracts. So there's the written, there's the verbal, and the intentional. But if it's not documented, then you can't really say that I have a copy of the printed thing and it doesn't include those elements that we talked about. You can't do that. So once again, any kind of negotiations, any kind of discourse between the two of you is not going to be on that contract, and therefore it's not enforceable. It doesn't necessarily exclude these previous conversations. Well, again, it depends on what those happen to be. Provides legal basis for argument to exclude it in a dispute later. Again, if it's not written down, it's not held accountable. The next term is inducement. Relevant if an employee was headhunted for that particular position. And again, you may have provided something for this individual. So the employee was induced to join the current employer, and you've actually defined that within that agreement. Clause recognizes that the employee's service with their previous employer. So if there has been that fact that they did come from that particular organization, we represent that within a clause within the contract itself. Expressly states that the amount of previous year's service that be recognized for the purposes and the benefits of termination notice of a new job. And again, it has a lot to do with how much time has actually been incorporated with either a third party or within that organization. So another area is independent legal advice, which in this case is a clause that outlines that the employee has had opportunities to seek independent legal advice before they had to sign that contract. And remember, I've said this several times now, you definitely, if you don't understand something, you want to have it checked out, because sometimes it is that one little clause that you didn't quite anticipate that can cause a problem. The example I gave you before, which was a simple one, where I wanted to cancel a contract and verbally I couldn't do it, in present I couldn't do it. I had to actually write something and send it to them in order to close that contract. And that was the only way of doing it. Well, I never read the contract's stipulation that was in there. So you need to read these contracts, and if you find something you don't understand, then you seek legal advice. And most lawyers will look at this, or let's say you can find somebody who understands this kind of verbiage. You might even find a student who's taking a legal program, or an instructor who happens to be teaching legal studies, who may actually go through it for you for $1 or $2 or nothing at all, just to kind of go through it. And we'll explain it to you. So once again, an employee will find it difficult to challenge the enforceability of a contract on the grounds that they didn't understand, but they just signed it anyhow. This is a common problem for people who buy secondhand cars. I got news for you. There's a lot of lawsuits about that. But in this situation for employment, it's the same situation. sometimes they find, well, you're supposed to work on a particular day, and they say, no, 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 and yes, 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 it's in the contract. So you can't turn around and say, oh, I didn't see that. Too bad, so sad. You signed it. And it's a legal binding connection between the two of you. Severability clause, a clause that states if a court invalidates part of the employment contract, the rest remains valid. As I said before, courts do not like to play with contracts. They will read through them. They will look for any kind of inconsistencies or ambiguities or missing clauses. There can be missing clauses like termination and other elements that have been forgotten to be put in. But they were never there when the contract was created. So they really don't understand why you engaged in the process of signing this thing. And therefore, if there are errors, then certain things can be invalidated, but not all of it. If one thing is shown to be in error, they can remove it, but they will not invalidate the entire contract. Remember, they weren't there. They don't know why you agreed to this. So a non-competition provision found invalid within a contract, remember, you may have no choice but to compete with that company because you still have a livelihood and you need to earn a living. So the rest of the agreement stays completely the way it is. Vital clause, any restrictive covenants are in the contract. So once again, restrictive covenants are upheld, unless of course it's proven that it needs to be reevaluated by a court. And once again, the rest of the contract will remain in force. The golden parachute. The only people who usually receive this particular type of a contract and this type of a section in a contract are those individuals in very high-ranking positions in a company. And there's a reason for this section. This is why executives are paid so much money, and sometimes obsessive in a sense as well, and bonuses and stock options and all kinds of other things. And it's very hard to remove an executive. There's an old adage, the higher you are in a company, the closer you are to the door. And when it comes to senior management and senior executives, this is absolutely true. When they're out the door, it's very hard for them to get a job again. It's really hard to find a job in the same area or even at the same level. It can take years and years and years of searching to find one. The reason is a very simple one. No one wants a loser. And if somebody has lost their job who has been a senior manager or let's say even an executive, then quite frankly, why didn't the company keep them? It's probably because they weren't that good to begin with, so why should you hire them? So this is what I mean by being closer to the door. Chances are you make one mistake and you're gone. So what they often have in their contracts is what we call a golden parachute, and it is extras, such as if they terminated them, they may have to pay them for 2 years. In other words, the compensation, they'll just keep getting a paycheck, and they're still on the payroll. And one of the reasons is because of why they get this. Without an executive, you don't have like a captain of the ship. So all of the employees don't have direction. A senior executive or a senior manager gives direction to their department. They focus its attention, they focus its skills in such a way that a return is returned to the company and therefore the company can move forward. But without these individuals, people would fundamentally end up doing their own thing. And of course, you wouldn't have consistency in a particular direction, and the company eventually would flounder. So it's recognized that they often receive much more. And therefore, if they are going to be removed from the company, they will receive all kinds of benefits, and sometimes they're paid off. In other words, you may pay them 10 years' salary just to get rid of them. Once again, as I said, no one wants a loser, so their chances of getting another job in the same field is really limited. Permits the executive to act in the interest of the employer rather than on their own. Remember, we don't want people just learning about how the business goes and then taking off or jumping ship and using that somewhere else. And also during transitional periods without being personally distracted. Now, once in a while, we find that there's embezzlement, there's all kinds of things. So what they're really trying to do is eliminate that possibility. Oops, that's it, golden parachute. So this is the type of job you want, senior executive, so that you get the golden parachute. Fantastic. So human resources, it contains so much that a human resource department actually is involved in. Not everybody does all of it. Sometimes some of them just deal with contracts, some of them deal with human resources for the acquisition of new resources, or some of them look for, let's say, benefit packages, training packages. Some of them deal with organized labor. Some of them have to do everything. And it's really a question of what exactly is the function, and there may be many functions. So contracts is a very interesting area and one that you cannot overlook. Very similar to Chapter 11 when we're dealing with harassment and also employment standards. You really do have to know those elements because, as I said at the beginning of the course, one of the things human resources is really responsible for, their mandate fundamentally is to ensure that the company remains legally compliant. In other words, it fulfills all its legal obligations, municipal, provincial, federal, making sure that that company doesn't break the rules. And you need to have a human resource department. Little companies oftentimes find it impossible because of the cost. It's just expensive to hire somebody for one function when they're not actually producing on a daily basis, but they're doing the documentation and the paperwork in the background. So having said all of that, there is any questions before I go any further? I tend to just get off top. Let's go a little bit. Any questions?
No, sir.
We're all waking up again. So the good news is there is an assignment which is due. Now, if you have not, and I know that several of you have already put in your assignment number 1 and assignment number 2, I was looking at them. Make sure that you are getting these all in. This is a very significant part of your final mark. So you definitely don't want to wait too long. So I still have to walk through them and grade them. So assignment number 3 is here. It deals with contracts. So I'm just going to open it up. I've also put the PowerPoints there as well, so that you have those. With a long weekend, I know how you're going to stay at home and you don't want to go outside because of the air quality and you want to stay inside and do some work. So this assignment will come in handy. So you're going to create an employment contract. I want you to read through the specifications here and then try to work it out according to the company you've chosen, the type of job that you've chosen. And you have latitude here where you can choose virtually any kind of company that you would like to actually use. So here it says it wants a small business center, which you're actually hiring for. And of course, you're going to answer these fundamental questions. And this is a breakdown of what is expected within that particular scheme. So you're going to break this down a little bit. You get 5 marks for explaining 5 or more obligations. Again, just take your time and go through this very carefully and make sure that when you're actually breaking it down, that you're thinking carefully about making sure that it makes sense and that it doesn't mean 20 or 30 different things. It's very specific. the term should be there, etc. So you're just putting a little contract together and answering a few questions. And this is due next week, about Wednesday. So you've got lots of time to do it, but I strongly recommend you don't hold off too long. Okay, make sure that you're actually working on it. And of course, it's giving you quite a bit of extra information here for a contract. It breaks it down a little bit, so that helps you to put it together. Does that make sense so far?
Yes, sir. Makes sense.
Fantastic. Let's see what just came through here. Put that in there. Okay, fantastic. So what I'll do is I'll let you go at this particular point. You can begin working on your project, which is assignment number 3. And I also suggest that you don't just take the entire weekend to do nothing. I know how easy it is to just relax, but remember that on Friday of next week, there is actually a final exam, and Monday's a holiday, so you definitely want to keep doing a little bit in the background just to make sure that you're keeping up with everything that's already been covered. Since the midterm until, in fact, what I'll do, I'll give you the, just let me give you the review for the final as well. So just the questions, so that you'll have something that you can refer to as you're going along as well. Just pull it up. Where is the review? There we go. So I've also placed a review in the chat so that you can take a look at it. We'll go over it again next week anyhow on Thursday, but I want you to definitely take some time to start focusing everything that you've learned. As I said, chapter 11 and chapter 12 are actually quite heavily hit. Chapter 12 may not be hit quite as heavily as it used to be, simply because there is a legal course that's coming up as well. And that will deal with Canadian law. So there'll be contracts and torts and other things in there like intellectual property. So having said that, I'll bid you adieu. You can have the entire weekend to enjoy yourself and study, study, study.
Okay, thank you very much. Have a nice weekend, sir.
Yeah, take care.
Ciao.